want to ask whether we should run them down time and the orders, you've already said enough about the orders.
I was going to the third one. The balance of convenience tilts towards the petitioners, because this is a big number that is being left out without reasons. As to his response, I would still say that the respondent is not going to suffer any prejudice if the graduation is postponed. Alternatively, he tells us what time he needs for the university to add the names of these students, because the university knows these students are qualified.
You are yet to file. Why?
For the reason that we came on record as well.
I find it convenient to start by quoting Dr. Willie Mutunga, Chief Justice, who said that the Constitution is the point of reference to each one of us. The truth of this statement is beyond question. In fact, it is a statement which can be said to have assumed the singular distinction of the force of the law. With the said truth in mind, as a prelude to this determination, I propose to take a 3-minute journey through the Constitution of Kenya 2010, a charter that has been hailed by many as fiercely progressive, liberal, and transformative. I will start with Article 1 of the Constitution, which vests sovereignty on the people of Kenya and decrees that and expresses in clear terms that it is donated to the 3 arms of the government to be exercised only in accordance with the Constitution. Just like another constitution in the world, if you look at Article 2, it declares its supremacy over all the other laws, and as if the drafters of the Constitution did not trust any person, the Constitution decrees that it is binding on no person, so that tomorrow someone does come and say it doesn't bind me. So it is binding on all persons. And the Constitution, to avoid any confusion, the word person is defined in Article 260 for those who do not know, so that nobody says I'm not under this bracket. Also to make sure that all respect the Constitution and to protect it from any assault, it decrees that it cannot be challenged in any forum, including this court. Further, in a departure from the past, it imports international law and states that it forms or they form part of the law of the land, provided that it conforms to the Constitution. Consistent with the supremacy clause, the Constitution decrees that any law, act, or conduct that is inconsistent with the Constitution is null and void. So again, as if the drafters don't trust anyone, Article 10 prescribes the values, that's national values and the principles of governance, which must be present whenever any person applies or interprets any law, policy, etc. So Article 22 guarantees the right to approach the court, even on the basis of a mere threat or violation of constitutional rights. Article 23 prescribes remedies available from this court. It never left us for us to decide what remedy to give. It lists the remedies available. Among those remedies are conservatory orders. Article 19 declares that the rights in the Bill of Rights belong to each individual and they are not granted by the state. Of course, Article 22 tells us how the court shall interpret and enforce the Bill of Rights. Article 48, the right to access the court. And Article 50, the right to have any dispute heard and determined by the court. Also relevant is Article 258, which guarantees the right to approach the court. Close to the matter before me is Article 159, which prescribes the exercise of judicial authority. And lastly, there is what I have called severally in my determinations the Great Command. You can call it the Great Commandment, And there's a reason why I'm emphasizing this in Article 259, which provides the manner in which the court shall interpret the Constitution. That is in a manner that promotes the principles, values of the Constitution, and also the development of the law. So, as I address the application before me, I am obligated to do so in a manner that will bring out the constitutional values and the principles, and also develop the law, because that's the duty of this court, to develop the law. In my view, constitutional litigation serves a greater purpose of enforcing constitutional values. This reminds me of the wise saying that we should not have a constitution without constitutionalism. Those who have read Professor Bua, is it Professor? No, there's another one from Nigeria. Nyambwezi. With inside knowledge of the foregoing, I now address the application before me. First, the arguments by the parties are fresh in my mind, and it will serve no purpose, no use to rehash them here. The record shows that the interim orders were valid for 14 days. They have since lapsed. The question of extension does not and cannot arise. The orders extracted are totally inconsistent with the orders granted by the learned judge. Second, the next issue is whether there are grounds for the court to grant a conservatory order or conservatory orders pending the hearing of the petition. I said earlier, conservatory orders are provided for under Article 23. Also, the petitioners argue that the petition raises constitutional questions. They have cited several. Authorities. No, they have cited the argument that they will be. Yes, wait. Yes, they have cited. They have said that the argument advancing raises constitutional questions. It's true that arguments citing violation of the Constitution do raise emotions, and the moment such violations are raised, the court's antenna must be raised high to ensure that the Constitution is protected. That is, the Bill of Rights is protected. But on the other hand, one accepted canon of constitutional interpretation is that provisions of the Constitution must be interpreted in a holistic manner. At the center of this dispute is Article 257 of the Constitution. It sets out timelines which this court cannot extend. Mr. Wekesa relied on Supreme Court decisions on this particular point. I need not recite them. By dint of Article 163, Subarticle 7 of the Constitution, Supreme Court decisions are binding to this court. This article is couched in mandatory terms. I've interpreted before, other provisions. It's an edict addressed to all courts in this country that they are bound by Supreme Court pronouncements. So I say no more on this point, rather than to add that Mr. Mamboleo relied on High Court decisions, which I've looked at them. They are not binding to this court. They are court decisions from courts of coordinate jurisdiction. And that this court is bound by the Supreme Court pronouncements. So again, I say no more on this point, rather than to add that the decisions from the High Court are not binding. Any order interfering with the timelines in Article 257 would, in my view, be unconstitutional and offend the basic principle of legality, which states that all decisions, including court decisions, must have a source in law. So, as we read Articles 22, 23, 258, and 48, we must also be conscious of Article 257. By the time the drafters inserted Article 257, they were already aware of the existence of Articles 22, 23, 48, and even 258, which is the next to one article after that. That is what we call holistic reading of the Constitution, to bring out the old purposes and values of the entire charter are not to stifle one provision and hoist another one over and above the others. In addition, one may look at the tests for granting conservatory orders. It has been argued that the balance of convenience favors maintaining the status quo and granting the orders. I do not think so. If the process proceeds and in the end the petition succeeds, the same can be stopped at that point by a judicial fiat. On the contrary, if the timelines set by the Constitution are interfered with, there is no mechanism in the Constitution or in the law of extending the same. And on this ground, the balance of convenience favors declining the stay, because it would have interfered with the constitutionally set timelines. It has been said that the petition will be rendered nugatory if the orders are not granted. A look at the petition leaves me with the doubt that it cannot be rendered nugatory. This is because in the event of succeeding, the process can be stopped, as I said. As said earlier, if the timelines are interfered with and the petition is eventually dismissed, the respondents will have lost. I have said severally that the duty of the court is to administer justice in accordance with the facts and circumstances of the case. The circumstances of this case are in favor of not granting the stay sought. Accordingly, the plea for stay is declined and dismissed. That's why I've gone. Let's agree on the timelines for the petition now. Parties have filed responses. If I were the one to decide, I would be asking you to think of going for the petition. Unfortunately, I'm not the one on duty next week, but that is my route, because these applications normally keep on wasting time. If you want to be heard and you want to take the risk, I can give you a date, try your luck in Mombasa. There will be a judge on duty, assuming she'll be able to hear you. Otherwise, there will be a judge on 26th, which should be the week following.
Much obliged, my lord. So, my lord, I wish to then urge the court